Welcome to our Making Sense of the Law series, and this one's about the management of first aid. I'm often asked by people, have the rules changed, or they get confused about what they have to do and what they don't have to do, so hopefully this explanation will help to set that out. So first off then, trying to understand the law, at the top here in red we've got what's called primary or statutory legislation. And we know if this is statutory legislation because it always finishes with the word Act. So for example, the Theft Act, the Road Traffic Act, the Health and Safety at Work Act. If it's an Act of Parliament, it means then that it's an offence if you fail to comply with it. So that's why here in red it says the word must. You must comply with an Act of Parliament unless you have a statutory defence not to. So for every act of offence in law, there's also a defence in law. Underneath Statutory Act, we've then got secondary or subordinate legislation, which for example is then called regulations, and regulations help you to try and comply with the Act. Underneath regulations, we then have the next category of national codes of practice and guidance. Underneath that then we've got policies and procedures. Now regulations is in amber, and here at the side we've got the word should in amber and as far as reasonably practicable. So if anything's a regulation or if it's codes of practice and guidance, then the terminology is here that you should comply with it or as far as reasonably practicable comply with it, unless the words at the bottom, it's not necessary, it's not reasonable and it's not proportionate in your circumstances. So you must comply with an Act of Parliament, but regulations, codes of practice and guidance, you should, or as far as reasonably practicable, comply with them unless it's not necessary, it's not reasonable and it's not proportionate. And instead you do something that's equal to or better than in relation to your particular needs. So then underneath this, workplaces write the policies and procedures. Then below this we've got training packages and audits. Now ideally training packages and audits on any particular topic should take into account and make sense of the Acts of Parliament, the regulations, the national guidance and codes of practice and policies and procedures, and taken into consideration safeguarding issues, case reviews, case law, special educational needs and disabilities and public opinion. Why is public opinion important? Well, just because there's a right in law to do something doesn't mean to say it's the right thing to do. And often Acts of Parliament are quite old and so their interpretations change as things go on. For example, the Offences Against the Person Act, which is still the current legislation, is dated 1861, but in 2016 we're still using that same act. So you might have a right in law to do something, but is public opinion still on the side of that particular thing? So in relation to first aid, the Act of Parliament, which we're looking at, is the Health and Safety at Work Act. There is no First Aid Act. It's connected to the Health and Safety at Work Act. And in the Health and Safety at Work Act, it does not tell you how to treat a casualty. It does not tell you whether you use plasters or not. Underneath the Act of Parliament, we've then got regulations, and for first aid, we've got the First Aid at Work regulations. Now in these regulations, it's more about managing first aid in the workplace rather than doing first aid in the workplace. And again, it doesn't say anywhere in the regulations how to actually treat your casualty. Then underneath regulations, we've got some health and safety executive guidance, which is called First Aid at Work. Now we also have some other guidance, which is from the Resuscitation Council, but that is all guidance. Then under there, you should have your workplace policy and procedure. So then when you get your training in relation to first aid and your audits in relation to first aid, it should be taken into account all of this, but plus your particular safeguarding, case reviews, case law, special educational needs, disabilities and public opinion. You must comply with the Health and Safety at Work Act unless you've got a legal defence not to, and you should, and as far as reasonably practicable, comply with the regulations, the guidance for first aid at work, and from those you then write your policy and procedures to fit your particular workplace so that your workplace policy, it's necessary, it's reasonable and it's proportionate. So let's look at this a bit further then in relation to the regulations. On page 2 of the First Aid at Work regulations, it says following this guidance is not compulsory and you are free to take other action. So there it's confirming it's not a mandatory thing to follow. Then inside it says the employer should make assessment of first aid needs. So you risk assess to work out what your first aid needs are. First aid provision must be adequate and appropriate. The nature of the workforce, for example, their personal demographics. So what's the age of your staff? What's the health of your staff? So unless you regularly or at least annually do some kind of questionnaire of your staff and ask them is there anything that they want to declare, how can you work out your personal demographics? And we can make general assumptions with kinds of work and age groups, but you can't get any better than actually hearing it from the horse's mouth. The member of staff then can always refuse to tell you any medical issues, but then you can't be expected to plan for their health and safety with that first aid issue if you don't know about it. First aid provision for non-employees then. The legal requirement is for your employees, but then for non-employees it strongly recommends that you take them into consideration. So they're your service users or your customers, and in schools your service user are your kids. In care homes it's the residents. All businesses it's your visitors, it's your clients. A suitably stocked and properly identified first aid container. Your needs assessment may indicate additional materials and equipment. The first aid regulations does not include giving tablets or medicine. The only exception is aspirin. Your first aid needs assessment is to identify how many first aiders you need, so there's no set figure. You need to then work out in relation to how many employees and other people that you have, the level of risk and need, then you work out how many first aiders you need and at what level of training those first aiders are. Your employers are to ensure first aiders undertake training appropriate to the circumstances of the workforce and your non-employees. So therefore you need to consider special educational needs, complex medical needs, comorbidity issues. Self-employed people working on your site, they should provide their own adequate and appropriate first aid provision, but that's something then you should take into consideration with your own assessment of risk and need. So then when we go to guidance then, so we've got a few aspects of guidance. We've got the Health and Safety Executive guidance, and then we've also got Department of Education guidance documents, and we've got the Resuscitation Council guidance as well. But if we look at the HSE guidance, which is the approved Code of Practice and Guidance, otherwise known as L74, on page 2 it states you may use alternative methods to those set out in the code in order to comply with the law. So here we are again with the equal to or better than principle, and there is no mandatory list of items that should be included in a first aid container. You base your contents of your first aid container on your assessment of risk and need. So then when we come to policy and procedure then, question to ask yourself is who writes your policy and procedure and what is it based upon? So review your policy, because a lot of your policy writers, they don't then understand the law in relation to what advice they're putting in there. And do you have musts or shoulds or as far as reasonably practicable in your policy? If you're using the term that staff must do certain things, if it's a must, is that because it's an act of parliament? And then if they don't do it, is there a sanction? Or can you reduce a lot of your musts and put it down to shoulds? Therefore the staff, based on their own training, their own knowledge, their experience, the individual circumstances at the time, they can make that dynamic decision based on the circumstances at the time. Are you satisfied that you're compliant with the Health and Safety at Work statutory legislation for risk assessing? For example, risks to first aiders from vomit, blood, stress, etc. Suitable training for assessed needs, taking into consideration your workplace demographics. So again, what's the condition of your staff? Once you're over 40, you're in higher risks for heart problems. Stressful jobs, high risk for heart problems, stroke, angina. Do you have staff who are on or have been on long-term sick with stress or depression? Do you have staff who are taking medications, and what is that for? Are your first aiders administering medication or cream? Because that's got some implications for you as well. So then when we look at training packages and audits, these should be taken into account, all of the law in relation to regulations, that the Acts of Parliament, but also the safeguarding, the case reviews, case law, special educational needs and public opinion. From a safeguarding point of view in first aid, it's deemed to be personal and intimate care. So is your vetting correct? If you've got vulnerable people such as children, then The latest recommendation in the 2016 Safeguarding Children in Schools is that anyone providing personal and intimate services and care, that these persons have got the highest level of vetting, so enhanced plus barred list checking. Also, issues to do with fabricated illness and induced injury. Would your staff recognise that? Would your first aiders recognise it? Do they know what it is? Would they also recognise incidents of self-harm, anxiety related or mental health recognition? And also stress levels to staff in the role. For example, if they're overly used. If you have low numbers of first aiders who then have a high volume of first aid to provide on top of the normal job, then you could find then that the person starts suffering from stress, and potentially we've got liability issues coming our way. Case reviews then to take into consideration. One example is baby Millie Thompson, who died in October 2012 after eating shepherd's pie at a nursery in Manchester. The inquest returned at that point a misadventure verdict and called for all staff to have paediatric first aid training. Millie's mother, Joanne Thompson, told the hearing that she thought her daughter was safe that day, and how she choked on mash we'll never understand. So that was 2012, and the choke at the time was deemed to be misadventure. But then there's been a couple of cases more recently which are taking a very different view on this, and so this is where public opinion's starting to come into it. So on the 7th of November 2016, a residential care home in Hampshire were convicted at Winchester Crown Court after an elderly resident choked to death on food. The home failed to conduct a suitable and sufficient risk assessment and were found guilty under Section 3 of the Health and Safety at Work Act. They were fined a total of £99,631, plus then on top of that will be all the legal fees. The Health and Safety Executive said this was a completely avoidable tragedy. The risk of choking would have been identified and measures put in place to control the risks. Another one as well, 2016, the council found guilty after the death of a vulnerable man who choked on his lunch at a daycare centre in Shrewsbury. The council were found guilty of breaching Section 3 of the Health and Safety at Work Act, and the fine was £65,000, plus then all the legal charges on top. The Health and Safety Executive argued that appropriate safeguards were not in place. The vulnerable man had a history of choking incidents, but staff on duty that day did not know this. Now, we have guidance on choke prevention policies for you, which are free of charge. Just drop us an email and we'll send you a copy of that, which you can then have a look at. Then in relation to special educational needs and disabilities, do you have tailored first aid training to fit your demographics? For example, if you have a service user with a condition such as cerebral palsy, which safe airway position would be suitable for them? Or example, if you've got a service user with feeding, breathing or waste tube systems, how would you manage a choke or a safe airway position? Physical intervention and crisis management wise then, and first aid. If you're dealing with service users who have crisis management issues, do your staff understand about specific conditions such as adrenaline overload, capillary bleeds in the head due to increased blood pressure, respiratory failure, fever fits? Then there's comorbidity issues. Do you have safe systems of work in place to monitor post-crisis health and well-being? Also in relation to, if we're looking at person-centred care during crisis, we need to take into consideration, is that person suffering from asthma or any kind of respiratory issue, diabetes, sickle cell, mobility issues, pregnancy, cardiac issues, neurological issues, head injuries. What if they went into respiratory failure? What would be the response of the team be? So we need to think there about medical and first aid implications pre, during and post intervention, because your standard first aid courses are not designed for anything outside of the norm. And if you are doing regular intervention with people, particularly people who have got extra vulnerabilities, then there are extra issues that you need to be considering in order to safeguard them. Also in relation to intervention issues and violence in the workplace, Freedom of Information Act from the education sector, it showed that in 1 year there were 4,372 assaults on school staff, and the common assault and injuries included these things: scratching, biting, spitting, threats and anxiety issues. So the staff suffering from anxiety as a result of this constant low level challenging behaviour. So there we need to look at the risks to staff and the child themselves and other people who may be injured. So the risks to the staff, but also the risks to the service user and anybody else, both from a first aid point of view and also from a wider variety of issues. What's your policy on your site about scratching, biting, spitting, threats, anxiety? Do you fully understand what the risks are in relation to skin compromise through a scratch, issues to do from the saliva in the bite, spitting and saliva in the eye? A recent liability claim was settled. The person received £110,000 compensation for receiving spit in their eye because the spit then ended up causing them some permanent damage to their eyesight. So then this brings us back then to this first slide that we looked at, and understanding the law in relation to first aid. So when someone says it's the rules, the question is to ask all the time is, what rules? What are they on about? It doesn't matter what the topic is. If people are saying it's the rules, what rules? Is it the Act of Parliament, and in which case, what Act, what section? Or is it regulations, which then maybe should be complied with, but you can then be flexible and work out whether it's necessary, reasonable and proportionate, and whether what you're doing is equal to or better than? Or is it just national practice and guidance? Or is it just your policy and procedure? And if it's your policy and procedure, then you can change your policy and procedure. But then do your due diligence on your training packages and audits, because if what you're receiving all the time for a lot of your topics is standard off-the-shelf training packages, then are you actually taking into consideration your unique and individual demographics of your particular workplace? Is it going to be enough to withstand any liability claim under breaches of the Health and Safety at Work Act, for example, and doing suitable and sufficient assessment of risk, suitable and sufficient then working out of need, and then given the suitable and sufficient training in order to negate that risk to the lowest level? And thank you for listening.